Hi, this is Chris Arnold. This is video 2 of the 4-video series called Preparing for the Initial Consult with Me. This one is about process options. So you and your spouse can choose a process to discuss your family law issues, that was video 1, so as to reach a resolution of those issues and write it down. These are the options I'll describe briefly as the process options spectrum, if you like. You can choose any one of these to resolve your family law issues. There are pros and cons, and I'm just going to go over them briefly here. KT stands for kitchen table. So that's the simplest, easiest, fastest, cheapest way to resolve your family law issues. With the power of the internet at everybody's fingertips nowadays, lots of people say, hey, I downloaded this separation agreement. Let's just sit down at the kitchen table and let's figure out what we're going to do. Upsides and downsides. The upside, fast, cheap. Two major downsides. One, without any legal assistance, without a lawyer or legal advice, you have no idea whether what you're agreeing to is within the bounds of what the law would provide for you. Are you giving away the store? Is your spouse giving away the store? We don't know because you don't have legal advice. This is an unsupported option. Part of the other problem is without legal help, when you write it down on the napkin or the piece of paper that's at that kitchen table, this has significant enforceability problems. So when the two parties don't have independent legal advice, judges will often say, I don't think they understood what they were doing. I'm not going to hold them to that bargain. So when you go to enforce the napkin from the kitchen table, you can have a judge say, sorry, I'm not going to hold the other party to this bargain. They didn't understand what they were doing. They didn't have independent legal advice. So cheap, fast, also uninformed, and can have significant enforceability problems. Let's look at the other end of the spectrum quickly. CT stands for court. Of course, that's not a voluntary process. You don't get invited to court, or you can't decline the invitation to court, let's put it that way. But it tends to be the most expensive, the longest, as in terms of time, and the most confrontational or divisive between you and your separated spouse. This isn't an attempt to reach a resolution that everyone's happy with. It is an attempt to have the judge give you what you want and to not give your spouse what they want. You're likely there because there isn't a lot of common ground between you. And very frankly, either it's very rare for there to be extraordinarily unique family law issues to be resolved. It's generally just somewhere that makes conflict between the spouses worse. And so you tend to get into a higher conflict mode over here, which drives the expense and the delay and the confrontation, which can degrade your interspousal and co-parenting relationship. In the middle, we have 3 supported negotiation options. Lawyer-lawyer negotiation. There's no structure there. Each party hires a lawyer, and those lawyers talk to one another. They can sometimes write long letters. They might have a meeting. The quality of this option will depend on the quality of the counsel. If you have one lawyer that just maybe dabbles in family law, doesn't know what they're talking about, they can give one or the other spouses bad legal advice or misdirect them, and then they can take a position that's not reasonable, which can really drag down negotiations. In mediation and collaborative, these are structures that people can choose to create those environments where the discussions can happen, generally supported by counsel, an individual mediator who is not representing either party, but if it's being done well, there will be an independent lawyer offline with each spouse. So these discussions can occur. Lawyer-lawyer negotiation, no structure. Mediation has a structure. It's a conversation between the mediator and the 2 spouses with the other lawyers, with each party's independent lawyer offline. Collaborative divorce, again, a structure, again, live meetings involving the spouses, but now both lawyers are in the room. That has the advantage that each spouse is feeling very supported. All their questions are answered. Their lawyer's right at their elbow for the entire process. Process options, differing amount of professional involvement, differing amounts of enforceability. So here's just a quick overview of what the choices are. We can discuss that more during our initial consult. Thank you.